Hello everybody, this is going to be my second video. I just wanted to apologize. Apparently the general feedback about the first one was that it was a tad long and took me a while to get right into the substance of it. So I beg your pardon. I suppose I saw more of it as an introductory, but if people really don't mind just cutting out the pleasantries, I just get right to the meat of it. Now, last time we left off with a general start into the nature of constitutional law, and now I wanted to start with the British model of that the founders built off of, and the powers of the respective branches of government. So let's just get right into it then. One of the most critical things to know about the U.S. Constitution is that it was modeled rather closely after the unwritten British Constitution. It was not the case that the Founding Fathers disregarded the Constitution of their mother country after the War for Independence, but rather they maintained that it was, at the time, the greatest Constitution ever developed. To again cite a historian, M.E. Bradford, he said, quote, "Our American forebears cherished the English Constitution and did not change their opinion of its merits just because Parliament and the ministers of King George III failed to observe some of its provisions. The Whig legalists who authored and then ratified the American Constitution were moved to emulation by its specific virtues that they had come to value more and more as they fought to protect them during the Revolution, and then struggled to institutionalize them as part of American law once the fighting had ended. Perpetuation was their objective, even sometimes when they modified the British original. As much as 3/4 of the document approved by the several states, including the Bill of Rights, makes no sense apart from an intimate familiarity with British legal history." End quote. More than anything else, the founders, having knowledge of the founders' undying reverence for the British Constitution is necessary in order to understand the setup of the institutions of the American system of government and the powers thereof. Because essentially, if you were to boil it down, the major, I suppose the axiom that they would use is, let's take the British Constitution, keep what's good, and amend what's bad. It seems pretty straightforward, considering that the primary first principle of practical reason is do what's good, avoid what is evil. It sort of plays right into that. It seems almost basic when you get right down to it. But the parallels, as an example, between the American and British government is actually, they're pretty obvious when you look at them. The British Parliament was and still is divided into two chambers. So is Congress. Parliament's lower house, the House of Commons, represented the empire's people directly. Congress lower house, the House of Representatives, does the same. The Parliament's upper house, the House of Lords, represented the empire's aristocracy, i.e. a body considered higher than the ordinary people, and its membership used to be determined not by direct election, but rather was based on heredity. Congress' upper house, the Senate, represents the states, also bodies considered to be superior to the ordinary people, and its membership was originally determined not by direct election, but rather by appointments by the various state legislatures. This has been done away with by the amendment, the 17th Amendment to the United States Constitution, which I would actually argue is a huge problem. I don't particularly care for it, but again, I can get into that at a later date. But regardless, the parallel still remains. The executive branch of the British system consisted of a single officer, namely a monarch, who, if he or she thought it proper, could veto acts passed by the national legislature. America's executive branch consists of a single officer, namely the president, who can veto legislative acts as well, although his or her veto, unlike the British monarchs, can be overridden by 2/3 majority of both houses. Finally, both Britain and America have a third branch of government vested in a judiciary with very limited powers. For the most part, these parallels extend to the duties and powers granted by the Constitution to each of the respective branches as well. This knowledge makes it much easier and clearer just what the founders meant to do when they endowed the government with certain powers. Any powers given to any of the respective branches of government were understood to be nothing more than those that the corresponding branches in Britain's government enjoyed, unless they were altered in the Constitution to suit America's needs more appropriately. Essentially, it's just they photocopied it and then used some whiteout to blotch out what they thought were errors or things that needed modification. And with that, one is now able to say with certainty that the phrases legislative powers, executive powers, and judicial power, which are all found in the United States Constitution, Article 1, Section 1, Article 2, Section 1, and Article 3, Section 1, respectively, they are all themselves terms of art. And again, I will hopefully elaborate upon these at a later point. I hope to continue on now with this lecture with just the terms of art pertaining to more than one branch of government or to the government in general for the United States Constitution. Again, to reiterate, the main focus of this work is not to cover all of the Constitution's terms of art, but rather just the most important and or misinterpreted ones. However, before we can proceed, there are some general terms which need to be acknowledged and expounded upon in order to understand more fully the very specific ones. The first is a seemingly ordinary or otherwise commonplace word, citizens, or citizen. It's used in different ways in the Constitution. There are also two other terms which are related, namely inhabitants or subjects. Inhabitant is rather easy, given that it generally referred to simply to a person who resided in a particular location. But even in that era, citizen was a rather general and ambiguous term. Strangely enough, even Blexton had very little to say about the actual definition of a citizen, but did touch on the basic ideas concerning it in his commentaries, where he discussed subjects who are, quote, aliens, denizens, or natives. He said, quote, natural-born subjects are such as are born within the dominions of the Crown of England, that is, within the legions, or as it is generally called, the allegiance of the king, and aliens such as are born out of it, end quote. Now, obviously, any references in Blexton to the Crown, England, and the king need to be altered to in order to understand what they mean for Americans. It seems that if one were to apply Blexton's words to the American system, the text might read as follows. This is me conjecturing, but again, I think it flows relatively nicely. Natural-born citizens are such as are born within lands and territories under the jurisdiction of the United States federal government and or the several states, end quote. Again, that's just my own, I'm trying to segue or make sense of it as it would stand for us. Here, we have to be careful since these definitions apply strictly to natural-born citizens. Upon closer inspection, we see that the difference between natural-born citizens and aliens is their allegiance to the king, or that is the government. By extension, one might formulate a definition of a citizen to be, say, quote, again, this is me conjecturing, but any persons who are full members of a given polity. Now, given the structure and context of Blexton's words, it seems that he used the term subject in such a way so that it would be either synonymous or near synonymous with citizen. So that much isn't too problematic. But second, there is the term behavior, spelled with a U, but it's the same word. It's used twice in the Constitution, once in Article 1, where it says, quote, each house may punish its members for disorderly behavior, end quote, and again in Article 3, where it says, quote, the judges, both of the supreme and inferior courts, shall hold their offices during good behavior, end quote. A majority of people concern themselves mostly with its application to the federal judiciary, so the search should begin there. In all of the political literature which deals with this topic, including Blexton's commentaries on the laws of England, Alexander Hamilton's Federalist number 78, and Joseph Story's commentaries on the Constitution of the United States, there's no explicit definition given for them, although it is used relatively frequently. However, the aforementioned works, and several others, coupled with a study of the term's context and purpose in the Constitution itself, can be of great assistance in ascertaining its meaning. And it would behoove us to, on this search for truth, to first examine what is the purpose and proper function of the federal judiciary. A good source to look to would be, there's a book by William Rawle, spelled R-A-W-L-E, titled A View of the Constitution of the United States of America. Because Rawle was a man who grew up during the founding era and was a judge and attorney in the early 1800s as well. His works, as a general rule, are very reliable. In this work, he began his section on the judiciary bluntly by saying that, quote, "No form of government is complete unless it is accompanied by a judicial power," end quote. He then continued, quote, "To make laws and to execute them are the two great operations of government. But they cannot be fully and correctly executed unless there is somewhere resident a power to expound," here I'm interjecting a definition, that is to explain by setting forth in careful and often elaborate detail, and apply them. This power is auxiliary to the executive authority, and in some degree partakes of its nature. But it is also required at times to control the executive, and what it decides to be unlawful the executive cannot perform. It may also in some degree be said to participate in the legislative power. Its construction of the acts of the legislature is received as binding and conclusive, although it does not prevent the legislature from repairing its own defects or clearing up its own ambiguities by subsequent laws operating on subsequent cases. A high function also appertains to the judiciary in the a high function also appertains to the judiciary in the exclusive right to expound the Constitution and thereby to test the validity of all the acts of the legislature. End quote. Now, see, I hope people won't think I'm rambling insofar as I'm about to quote something from Federalist number 78, written by Alexander Hamilton. Now, keeping what the quote that I just had in mind, I'd like to read this bit from the Federalist 78, and hope that people will see how well they mesh. Quote, "According to the plan of the Convention, all judges who may be appointed by the United States are to hold their offices during good behavior, which is certainly one of the most valuable of the modern improvements in the practice of government, and it is the best expedient which can be devised in any government to secure a steady, upright, and impartial administration of the laws. Whoever attentively considers the different departments of power must perceive that in a government in which they are separated from each other, the judiciary, from the nature of its functions, will always be the least dangerous to the political rights of the Constitution, because it will be least in a capacity to annoy or injure them. Now, just to close that off for a minute, obviously, over the course of the last few decades, it's proven to be actually very dangerous. So in that respect, Alexander Hamilton may have been off a little bit, but assuming that the judiciary actually maintained its role in being responsible, not activist, if it were in fact strictly constitutional and not acting in an activist way, it would actually pose very little danger to the American people. But again, still, because of the way things have progressed, he seems to have been off a little bit on that. Regardless, the truth of his writing still shines forth. To continue, quote, "The judiciary may truly be said to have neither force nor will, but merely judgment, and must ultimately depend upon the aid of the executive arm even for the efficacy of its judgments. The courts were designed to be an intermediate body between the people and the legislature, in order, among other things, to keep the latter within the limits assigned to their authority. The interpretation of the laws is the proper and peculiar province of the courts. This conclusion does not by any means suppose the superiority of the judicial to the legislative power. It only supposes that the power of the people is superior to both." End quote. Now, from both these excerpts, it is clear that the main, and some would argue sole, duty of the judiciary is to apply the laws to particular instances, namely in cases and controversies, as is prescribed by the Constitution. And in this respect, it acts as a kind of buffer between the people at large and the federal government. Now, of course, the legislature may pass and make laws that regulate the people's rights, and the executive can enforce them. However, in enforcing laws passed by the legislature, the executive, or as is far more likely, executive officers under his control, must bring persons accused of breaking said laws to trial. This is where the judiciary's role comes into play. The courts may obviously pass judgment on such cases, but they also have the responsibility to consider if the law being enforced is in fact legitimate. That is, before they can just decide whether or not this person is guilty or not guilty of violating the law, they also have to decide whether or not the law that the people are trying to be convicted, that the prosecution is trying to convict them under, was in fact legitimate at all, or whether it stood in opposition to the Constitution and is therefore void. Therefore, the person being tried would not be guilty of anything, even if he had broken the law, considering that that law was not actually valid. This is the appropriate meaning of the power of judicial review. I would recommend, for a series of good comments on this power, to read a book by Walter Burns, B-E-R-N-S, called "Taking the Constitution Seriously." He had a pretty good excerpt on that. But the power of judicial review, I plan on elaborating on a little bit later. If the judiciary perceives that the law is in conflict with the Constitution, then its members may say so, and in that respect dismiss the case, since they are duty-bound to uphold the Constitution before they uphold any given law. And they're shielded from the other two branches of government for doing this, and then that's essentially what solidifies what's known as judicial independence. On this subject, Hamilton said that there is no position, quote, "there is no position which depends on clearer principles than that every act of the delegated authority, contrary to the, can I start that over? Said that there is no position which depends on clearer principles than that every act of a delegated authority, contrary to the tenor of the commission under which it was executed, under which it is exercised, is void. No legislative act, therefore, contrary to the Constitution can be valid." End quote. That's also taken from Federalist 78. What does all this have to do with good behavior? Well, given that this term is meant to regulate how judges act, among other things, the first part of its definition would probably be as follows. Good behavior refers to any and all behavior becoming of a judge. That is it appropriate for him to exercise it? However, this cannot be the whole of it. To reiterate, it is the duty of a judge to safeguard the Constitution and to apply laws in an equitable, upright, and impartial manner to all cases and controversies which come under its jurisdiction. Therefore, if a judge exhibits behavior, criminal behavior included, which suggests that he is not able to fulfill these duties, i.e. he is no longer of sound mind, willfully or knowingly substitute his own opinions for the Constitution and or legitimate laws, etc., he may be impeached and, if convicted, removed from his post. Good behavior, however, does not necessarily apply to every professional indiscretion. For instance, if a man is known to be an alcoholic at home, such a thing would best be considered before he's appointed or confirmed to a new position. However, so long as this disgraceful behavior is restricted to his own home and does not affect him in his duties as a judge, the term good behavior does not seem to apply here, although this may change upon studying the meaning later of the term of art, high crimes and misdemeanors. Again, I'll get to that later. I know it seems like I'm putting off a lot till later, but there's just so much history and beautiful potency almost behind all these words that they need to, the entire thing needs to be fleshed out. So bear with me. With that said, it is not too much of a stretch of the imagination to suppose that the other relevant provision, the one concerning disorderly behavior of members of Congress, is much the same, but also includes behavior which is disruptive of the business of the federal legislature. Now, I know it seems like a lot of this has been sort of technical, or stuff that would be appreciated by a technocrat, but it is important because eventually it will play out when I go into a further explanation of judicial review and how it pertains to how the court has exercised it since the landmark case from 1803, Marbury versus Madison, which is so often quoted by by the judiciary or by people who take part in the judicial process. But again, I hope no one will mind if I leave off on that for this time, and we'll pick up next time with the discussion of the more general terms of art. Specifically, I want to lead off next time with high crimes and misdemeanors. But so far, I would like to thank everybody for sticking around through the first one. through the first of my videos, and in the positive feedback that I've gotten so far for it. I apologize again for last time making the lesson so long, and this one I'm keeping at just about 20 minutes. So I'll let you go here, and hopefully we can pick this up again next time. Again, I appreciate anybody's continued support, and the more you spread this stuff around, the more I can get the message out. So please, by all means, if you agree with what I'm saying and you think that this can be sent around the world or more than I care about, around the country, please, by all means, forward this to friends and other people. In the meantime, I'll let you go. But again, thank you very much for listening, and I'll see you next time. All right, bye-bye.